Questions at all before we get started for the evening? All right, so tonight we're going to get into leasehold interest. If you remember back to chapter 7, we talked about the two different types of estates very briefly in that figure 7.1 in the textbook, where it has freehold estates, and that was what chapter 7 was about, various types of freehold estates. And tonight we're talking about leasehold estates. So this is the other way in which to have an interest in property. So just some basic terminology here. This is all in the text, but make sure you understand who's who. So the lessor is the property owner, the landlord, the landlady, whatever, the person who owns the real estate or entity that owns the real estate, and the lessee is the tenant or the renter. Now, if you remember that, we've used the term tenant for a number of different things. We use joint tenant, tenancy in common, tenancy by the entirety. We use tenancy there for co-ownership form, and then we're using the word tenant here again for somebody who's not an owner of property. So I gave you a little bit of a definition here just to kind of point out that the word tenant isn't only for the way we typically use it, right? I mean, so just because you see the word tenant in the description does not make that person an owner and does not necessarily make that person a renter. You have to look at the context. You have to see what it is. A tenant is just somebody who has some kind of an interest in property. All right, so leases do a number of things for us. One, they're a conveyance of rights. It's part of what happens. Remember back to chapter 7, I think I also gave you some basic rules of thumb. One is that, you don't have, if just because you own the whole thing doesn't mean when you convey it, you have to convey everything you have, right? And that's what happens with a lease. So the landlord, we presume at this moment in time, has a fee simple absolute interest in the property. The lessor owns it, right? They have a title right type interest, and they're going to make a conveyance of some sort, partial conveyance of rights to the tenant, to the renter. Well, that's one of the roles that a lease fulfills. You don't have a deed here in this case because we're not transferring a title right like that. We're transferring a temporary interest of sorts, hence the idea of a leasehold. So the lease serves as that purpose. It transfers rights from one party to the other. Now the landlord retains then a reversionary interest, right? Because when the tenant leaves, what happens to the rights? They all revert back to the landlord. So, when you own property, again, in theory, without worrying about all the other laws and constraints of, that are placed upon us as property owners, you have the full bundle of rights. But when you put a tenant in there, you convey to that tenant some of those rights, contingent principally upon what the lease says, right? In terms of what is going on there. I mean, if the lease is silent, based upon how common law is worded, and we'll talk about that in just a minute. So again, the landlord has a reversionary interest in a property that's already been leased, or a portion of a property that's been leased. It's non-possessory, and you don't possess it anymore. You don't use it basically as the landlord. You convey that part of that property or that property in whole perhaps to somebody else, and it's a future interest. So it's a future possessory interest after, when it comes back to you. But at that moment in time, your rights are somewhat restricted. Right? So typically, we would say that the landlord goes from a fee simple interest to a leased fee interest. This is particularly true when a property is leased for more than a year. So combining some of the things we're going to talk about tonight with some of the basic principles we've learned along the way, and with some things we're going to learn 2 weeks from tonight after spring break, go to chapter 19 on appraisal, we can get a sense that this idea that if you lease a property for longer than a year, so typically not housing, or if it is, something that's really high demand where you can get a 2-year lease or so for the property. So if you lease property for a long time, you're considered to have, as the owner, a leased fee interest, because everything about what you own and what the value is of what you have is based upon the value of the income stream if the leases are for longer than a year. Whereas if the property is leased for a year or less, we're going to value it based upon whatever the current market rents are, because you could probably turn that tenant over within a year if you needed to get at the higher possible rent, or a lower rent if they decide to leave and reduce it. So again, fee simple is what we looked at in chapter 7. Lease fee is kind of what we're talking about here if you have a long-term lease situation, and it does matter. Okay? Yeah, so the tenant has the current possessory interest. The landlord retains a future possessory, but basically reversionary right in the property when we make that conveyance. Since we're talking about rights and conveyance and who has what rights, if you've already looked this up because you've read this and news was coming, that's fine. But without looking, without going to your textbook or to your notes, who remembers the bundle of legal rights from chapter 2? Same stuff we reviewed in chapter 7. What are those 5 rights? Anybody? Enjoyment is one, yep. Yes, you have possession, right? Enjoyment. What else? I can't hear you. Exclusion? Yeah, exclusion. You got one with a C and one with a D.
Disposition?
Yeah, disposition.
And control?
And control, very good. So in whatever order, the basic idea of the bundle of rights. So then the question is, since we're making a conveyance from the owner of the property, from the fee simple owner of the property, we're making this temporary conveyance of rights to the renter, to the lessee. What rights are we conveying? Let's assume that the lease is silent in whatever I'm about to talk about, because the lease is a contract. So looking at contract law from chapter 11, so long as it contains all the essential elements, in other words, it's legal, one party didn't bargain unfairly to sort of dupe the other or trick the other one into entering into something they didn't understand, and there's consideration and meeting of the minds and all that sort of stuff is there, then the parties can pretty much agree to anything in a lease. Right? Whatever the parties want to agree to in a lease, if it's legal and the court would uphold it, it's probably acceptable. But absent that, looking just at the common law, let's just kind of think about these rights. So let's just talk about sort of the bundle of rights. If the lease didn't say anything, if all the lease said is, I own this house, I'm leasing it to you for a year for $1,000 a month, here you go, would the tenant get possession? What is possession really? It's sort of use, right? I mean, you have to sort of possess it, use it, right? So that would be fundamental. I would agree with that. Was Steve's observation. Yeah, so that's probably right. The tenant's going to get full possession of that space. And when is the landlord going to have the right to possess it again? When the lease terminates for whatever reason. It's in default, or it just runs its course, or mutual agreement, or whatever. How about the right of enjoyment? Thinking in terms of more like quiet enjoyment in the title, when we talked about chapters 12 and 13, that idea of quiet enjoyment, right, where the landlord, excuse me, the owner of the property has a title right that assures them that they're going to be defended from or not be victimized by other parties' claims to title. So thinking of enjoyment that way, right, would you agree that the tenant should know that that space is theirs and somebody else is not going to come take it away from them during the term of the lease, so long as they do what they're supposed to do, pay the rent or whatever, right? So would we agree that also that the tenant would receive the right of enjoyment? Okay. How about the right of control? Who controls what goes on with that space or that property or whatever? Does the tenant control that, or does the landlord control that? Okay, so I've got a few landlords. Anybody want to side with the tenant or no?
Wouldn't it need to be specified?
Well, I'm saying if the lease doesn't specify,
No, yeah.
so you're saying the tenant would have control. So a little bit of each. What about exclusion? What does the right of exclusion give us the right to do? Say who can and can't come on the property, right? So does the tenant receive the right of exclusion if the lease says nothing about it? Does that right of exclusion extend to being able to exclude the landlord? You were pretty confident in your head nodding there. There's a lot of energy going into that. So would you agree then, does the tenant have the right to exclude the landlord if the lease says nothing?
Yes.
Steve says yes. He's even more confident now than you were 30 seconds ago. What do y'all think? Who has, if the lease doesn't specify these things, who has control and the right to exclude people, including the landlord, him or herself? The tenant? Pretty good chance. I'll go to that a little bit further. Let's take a look at this last one. Maybe this is going to be a little bit easier than some of these sort of, because we were pretty comfortable when we knew what was happening here. A little less so here maybe, but the right of disposition. So what do you think happens there? I mean, does the tenant have the right to dispose of the property? Do they have the right, any kind of right of disposition whatsoever?
Would sublease be a disposition?
Ah, it sure would be. So it goes back to that rule of thumb. Just because you have the whole thing doesn't mean that you have to convey it. What was the other part of that? You can never convey more than what you have. So if the lease is silent to this effect, the tenant gets all of these rights, including the right to exclude the landlord, including control of what goes on in the property to all extent other than what's impacted by the law, and the tenant has the full right of disposition. Now, the tenant can't sell the property because the tenant doesn't have a title right? They have a different kind of interest. They have a leasehold interest. But they do have full rights of disposition, including to assign or to sublease, unless the lease says otherwise. So it's an important lesson to anybody who's a landlord or wants to be a landlord, and this is, I think, what Kate was leaning towards. These things are pretty important. Shouldn't the lease specify? It should, especially if you're the landlord and you don't want your tenant to have full rights on the property. If you want to be able to say, for example, within 30 days of the lease expiration, if you haven't renewed or signed on for the, or exercised your option for the next lease period, we have the right to start showing the property with 24 hours notice, for example. Or if within, any period of time during the lease, if we decide to market the property for sale within 24 hours, you have to, you have to allow us to show buyers and agents or whatever through the property. Because if you don't put that in the lease, then the tenant has certain rights within reason to say, no, this is my space. I'm a tenant, and you call me at Monday morning at 10 a.m. and say, hey, got buyers to look at this 8 unit that you're renting, and a unit of, and we would like to get them in there as soon as possible. And I say, look, I'm a single parent. I work third shift. So either I'm sleeping or my kids are home alone, and either way, you're not coming in during those times. So, and the way my schedule is such, the next time I have available is Sunday. If the lease doesn't force the tenant to make that property available in some form or fashion for those buyers or agents or whomever, the tenant probably has full right to stand on their rights, their common law rights of saying, no, this is my space. This is my apartment, not yours. You own the building, you own the common elements, and you own all of that, but for right now, I have an interest that controls and decides. So again, very important for landlords to have leases that reserve for them or create for them certain rights that the common law necessarily does not. We really didn't talk about this in contracts, and this is where I usually address it, but this is a contract law issue, so pay attention, this matters. If you have a hair-splitting or fence-straddling kind of dispute between two parties to a contract, courts will typically decide against the party who drafted the contract if they just can't otherwise decide. If both parties have a reasonable position and take a reasonable interpretation according to the court, then the law is going to err on the side of protecting the party who was the recipient of the contract draft from the other, because it's presumed that he or she who drafts the contract had the best opportunity to create things in their favor, and if they failed to do so, and we have to split that somewhere, we're going to split it in favor of the other party. So again, whose lease is it usually whose contract is it usually in a lease arrangement? The landlord's, right? I mean, as a tenant, you don't run down to Office Depot and pick up a copy of the lease to hand it to every landlord you go to see apartments at and say, this is the lease I want to use, right? They say to you, here's our lease, look it over. Same thing is true with commercial property. There are some exceptions. State of Illinois, tenant for me, for example, has their lease, and we use their lease form. That's what they require. It wasn't always that way, but that's the way they do things today. So large tenants, or, you know, some major tenants, sometimes they'll have their lease form that they insist on, and you'll work from that. But in commercial, you tend to also, both parties tend to employ lawyers, and it's hard to know who drafted what when it's all said and done at the end. But in a residential kind of scenario that a lot of us are going to be most familiar with, if the landlord doesn't get it right, the court is oftentimes going to side with the tenant just for the fact that it's the landlord's lease in the first place, even if it came from LegalZoom or NOLO or Staples or wherever they happen to get it at. All right, so any questions about those issues of rights and you know, how that works and how important the lease is, really for both parties, and especially for the landlord to get it right? One of the things I'd like you to take away from tonight's class is that leasing is more like owning than less. You know, we tend to look at this and say, well, you can either lease property or you can own property. If you own it, you're really controllable. It's yours. You can do with it what you want. Leasing works the exact same way, except that in some manner it's defined to end, and if the landlord's smart, they can limit the rights that the tenant ends up with. But in effect, what you do as a tenant is you buy the use of that space. You buy those rights, you just do it for some specified period of time, and you make payment in the form of an installment contract. A lease is not just a conveyance document, right? It's also an installment document. You pay $1,000 a month for that apartment. But if you rent an apartment for $1,000 a month for a year, what you've really done is pay $12,000 to buy the rights to use that space within constraints of the lease or common law, and you're allowed to pay monthly. But the obligation is a full-on annual pay for the entire thing obligation. So if you're operating a small business, say in 10 years you've got your own real estate brokerage and you want to go to a really high-end building for your, for your brokerage firm, or whatever building you want to go to, and you want to sign a 10-year lease, and you're there for 3, 4, 5 years, and business is so good that you've grown out of your space, you got to remember you still have an obligation for the remainder of that 10-year lease. So it can be a challenge for a business. What space do I rent? How large am I going to get? How small may I need to scale down to? What happens if, if business is terrible in 2 years? What happens if business is excellent in 2 years? Either one of those scenarios can create a challenge, because your obligation is for the full term and duration of that contract. Some state laws and some state courts particularly will favor tenants with the right, residential tenants with the right to leave and only face maybe a couple of months worth of rent when they walk away because they can't afford it or they got transferred or whatever. State of Tennessee, for example, if I remember right, a situation I looked at for somebody there 5 or 6 years ago, by law, you sign a lease, you're there for a month, you get a job transfer, or you just decide it's too much money and you walk away. By law, that landlord cannot hit you for more than 2 months of rent for the space you never used. And in a state like Illinois, the landlord has an obligation, an affirmative duty, we call it, to mitigate the tenant's damages in any case, but in a residential case especially. Although there's no statute that I'm aware of in the state, courts will probably expect the landlord to mitigate the tenant's damages. In other words, get it leased in a couple of months. That should be enough for you to get it released, and once you have it released, you got relet to somebody else, then let the tenant out of the rest of the lease because you're no longer damaged. That's kind of the way we look at this, because the consumer is usually taken care of, and the business person, the investor, is usually looked to have greater capacity and deeper pockets and all that sort of thing. But in general, theoretically, particularly if you're not talking about a single-family residential type lease or apartment type lease, tenants are obligated for that full duration. So if you're a business operation, you won't get the same tenant protections that a residential tenant might get. As most of you are aware, single-family residential rentals are usually for a year. It isn't uncommon, however, for in places like Naperville or other places where properties are highly sought after, maybe a downtown lakefront Chicago condo or whatever, where certain single-family properties, the lease term will be 2 years. Multifamily scenarios, like within apartments, it's almost always annual. Although, of course, in either one of these scenarios, what can happen after a while? It just goes to a month-to-month thing, particularly after some period of time. And that's up to the parties. You can rent month to month, of course, if you want, as a landlord and the tenants are interested. The problem with month to month is it's easy for either party to get out of their deal. It's not a very long-term contract. The tenant's not secured in how long they're gonna be able to stay, and the landlord's not assured of a very lasting income. If both parties are okay with that, which usually they are after some period of time, then you'll start shifting into that. But initially, you usually need to have something of length. Commercial and industrial leases, the shortest term that I really like to deal with ever is 3 years. That doesn't mean we don't have shorter terms. Get people to rent for 6 months, a year, eventually month to month, depending upon their scenario. But if I'm crafting a new lease, 5 years is the standard for me. The longest I've ever toiled under with anybody or with tenants, either as a broker or as an owner or a property manager, has been 10 years. But it's not at all uncommon for major tenants, particularly large retail tenants, or major anchor tenants in a downtown high-rise office building, for example, to sign a 20 or 30-year lease. Walgreens, when they're signing leases today for their stores, those are very commonly 30-year leases, or 20. In 20 years, you can have the building paid for. So you develop a property for Walgreens, you charge them enough rent that it covers the cost of everything. In 20 years, literally, the mortgage could be paid off, and you hopefully still have a tenant, but you also have a building that's paid for. So, again, the terms are much longer. Why is Walgreens willing to commit to 20 years? And they do a lot of site evaluation up front, and if the traffic is what they want, what they expect, the location is what they're looking for, they pull the trigger, and they don't want to lose that location 5 years out, 10 years out. They want to know that they're going to be there consistently for a long time. Different mentality than we have as individual people. Term that's not in the text, and you need to know this possibly for your state exam. I think I've used it once or twice already. The idea of economic rent, otherwise known as market rent, versus the term contract rent. I've seen the term economic rent on state exams in Illinois twice. Once on my broker's exam, I believe, and once either on my I think once on my instructor's exam, which is another version of the broker's test, basically.
Can you explain that? Can you go over that again?
Yeah, well, I'm going to explain it more fully yet. So economic or market rent is what would something rent for today if it were being rented. We're going to talk a little more about market value of properties for sale in Chapter 19, but we touched on that already when we went through taxes and a few other things. So property has a market value. Rental property also has a market value, and that's basically the issue of market rent or economic rent. So even if a space is already rented, economic rent would ask the question, if that space were available right now, and if a tenant were interested in that space right now, at what number would the landlord and the tenant come to a deal today? Current value of the property then can be looked at based on that if you need to for some particular reason. So again, economic rent or market rent says what would the space lease for today if it were leased today. Just like market value in a sale number is what would something sell for today if it were to sell today or at a particular day. Contract rent, on the other hand, contrasting against economic or market rent, contract rent is what does the lease say? So if your residential tenant is only paying $800 a month to rent the house, but market rent is $1,000, at what number should we value the property? The contract rent if it's a single-family residential, or the economic rent? Because those are two different values. If you got $800 for what people are actually paying, the contract rent, and $1,000 for economic or market rent, at which number do we value it and why? Well, with residential, we said the lease term is typically how long? 12 months or a little bit less if you have less left on that or if you default into a month-to-month scenario. So in the typical residential rental case, the presumption is you can turn that tenant out and replace them with a higher paying tenant if the market rent is there to do that, if the economics are such that it works. So we'll value the property in short-term rental kinds of scenarios like residential based upon economic or market rent. So for investors interested in finding some place that they can sink their teeth into and make some money at, if you find that house where it's rented at $800 a month and you're convinced you can get $1,000, the asking price really should reflect the $1,000 a month. But if it doesn't, if it's reflected based upon the current $800 rent or that plus a little bump, then there's a deal to be had there, because you can pretty quickly turn that tenant out and replace them with somebody who'll pay $1,000 if your market assumptions or market study is correct. But if you're pricing that house as a listing agent, you should be pricing it based upon economic rents, not on the rents that your landlord is actually getting. The same is true in any residential property, including apartment buildings. Don't look at what the rents are, look at what they should be if they were leased according to economic conditions. That's why this concept is important. It isn't just knowing the terms, it matters a lot. Looking instead at a commercial or industrial kind of property, let's say that the economy is in the tank, it's 2008 and leases have dropped, or it's just after 9/11, 2001, and leases have dropped, values have dropped significantly, people don't want to rent. But you've got a triple grade A super egg sucker tenant in there paying what was market rent when they signed up, but today is way above market rent. What are we going to value that property based on? They're way above market rent, contract rent, or what it would rent for today. It all comes down to how much time is left on the lease. If it's a leased fee interest, if that lease is good for more than a year, then we're going to base it on the contract rent. Because if you can turn around and sell that building, and that lease runs with the land, as leases do, unless there's a cancellation clause, in the case of sale, which most leases aren't going to have, then we value properties that have long-term leases on the value of the contract rent because it's in place. Unless you don't think the rent is going to be paid. If you think the tenant's going to go out of business, then you analyze it based on that, because you don't expect the rent to stay there. All right, so that's where this idea of time length and rent amounts and type of facility and valuation all come together. Again, a lot of this stuff isn't in the textbook, but there's always investors in the class, or there's always the chance that some of you might want to become that, or that you might work with investors. You need to kind of understand this basic concept. We'll talk more about this in 2 weeks when we do chapter 19, but leases drive value. Leases drive value in rental properties, period. We'll look at that in greater detail, but other than possibly single-family housing, which can always be turned back into a single-family house, at pretty much you kick out the tenant and you move yourself in. Other than that kind of property, for all other properties, they're going to be valued based upon either what they're leased at or what they could be leased at, given different market situation. All right, so again, we talked about freehold estates in chapter 7. So now the leasehold estates we're going to talk about here in name and by definition that you need to be able to identify. We'll start off with an estate for years. And like all things, all good things in a college course, it's a little confusing, right? It's a complete misnomer. Because an estate for years doesn't have to be years for years at all. What is an estate for years, really? It's an estate that has something definite about it. A definite time period, right? That's what an estate for years is. We know when it begins and we know when it ends. And that's what matters most in here. And I've got a bunch of other names up here that's got, you can call it a bunch of different stuff. It all means the same sorts of thing. But if you think about it, the landlord has a future interest and they'd like to know when that's going to come back to them. Right? When is their future interest going to become a current possessory interest again? And the tenant would also like to know, hey, if I decide to leave at some point in time, am I supposed to tell somebody, or can I just pack up and go? So the question of which estate is it, or which leasehold estate is in play here, really comes down to what kind of notice does the tenant have to give the landlord when they're choosing to vacate, and what kind of notice does the landlord have to give to the tenant if they want them to vacate. That's really what the whole idea of leasehold estates come down to. So as long as we have a definite time period, we have an estate for years, it could be 24 hours, you can rent the banquet facility for, for a wedding reception, or it could be whatever. But it's some, specifically specified time period. Well, the termination notice requirement of landlord to tenant, if the lease is scheduled to end on May 31st of this spring, right? If I'm the tenant and I want to get out May 31st when my lease is scheduled to, my leasehold estate is scheduled to end and it's an estate for years, what kind of notice do I have to give the landlord? None. And why is it that I don't have to give them any? The notice is already given, right? Because it's right in the lease. It's in the original lease agreement. The same thing is true in reverse, right? The landlord does not have to tell the tenant, you must be out by May 31st. It's understood. The tenant's already been notified, and the landlord has the right to expect that on June 1st, they can walk up, change the locks, and put somebody else in the space. Whether it's an apartment or an office, it doesn't matter. And, so in either direction, that's how it works. No notice is required under an estate for years. So what do I need to know about an estate for years or tenancy for years? Definite time period, which means no notice is required by either party because it's already been specified in the lease. That's pretty much it. All right, so assuming that a tenant stays, for example, or you just rent it this way from the beginning, you can end up with an estate from period to period or any of these other names. Again, it's all just mushing around the same terms and synonyms to create a bunch of different possible definitions. But here now, under a periodic tenancy, we don't know when it's going to end. We just know when it can end. The most common form of this, of course, is a month-to-month arrangement. That's what you're the most likely to see. So some of you may have rented on this kind of a basis. Again, particularly you rent an apartment, you're there for a year, for 2 years, whatever, or a house, and then you want to move, so you don't want to lease up for a whole other year, but you're not sure if you're going to be there for a month or 6 months or 8 months. At that point in time, the landlord may say, oh yeah, whatever, just let us know, just give us notice when you're going to leave. Because there's no more cost to them, they don't have to show it, now that you've given them kind of notice that you're going to leave at some point, they have a rough idea and they'll work to that. So, if you're going to be a month-to-month tenant, what kind of notice? A month. And it's actually not really, 30 days, it's really a full period plus any portion that's remaining. So, again, for the lease that is turning over, at the end of every month, so we use May 31st as the time I want to get out, and assuming I'm on a month-to-month, it's not good enough that I give the landlord notice on May 1. Because I've already breached that whole period. I'm now into that period of May. Notice on May 1 should get me out by June 30, as I understand that. So it's really a full period or whatever it is, and nothing more. And that's the one here that really makes a lot of sense to know, because that's the one that's most likely you would see in practice, is 30 days notice in Illinois for a month-to-month tenancy. If you want to memorize all the rest of these, that's great. I don't know that they're that valuable. And like a lot of things in life, after the test is over, you need to know them, look them up. I've done a lot of month-to-month, I've done a lot of periodic tenancies, and they've always been month-to-month. All right, so that's that idea. So for a landlord, if they want to get the tenant out, same thing is true. Notice, got to have at least a full period. I can't tell my tenant on May 1, I want you out May 31st. I tell them on May 1, now they get to get out as late as June 30th. Questions about any of that for periodic tenancies or whatever? These last two leasehold estates are created when a tenant stays beyond their original term. And there's basically two different scenarios that can play out. Either the landlord is accepting of the tenant being there, or they are not. So you have a restaurant in your building, for example, and they're paying an okay rent, and they're struggling to get by. But you recently had an inquiry from another kind of use, a tenant with another kind of use, and yes, it would cost you some money to tear out the equipment or whatever, but this new tenant will sign a 10-year deal, and they're financially strong and stable, and they'll put up a bigger security deposit, and in about 5 or 6 years, you will have made money even though you have to pay to get rid of the current tenant's equipment or whatever. So you're expecting that on June 1st, that restaurant's gonna be gone, and you'll walk in, change the locks, start doing the build out for the new insurance agency or bank branch or whatever you're gonna put in there instead of this little mom and pop restaurant that struggles. And you get there on June 1st, and there's one of two possible scenarios. One is the tenant's gone, in which case you're happy. In the one case, they're not, which in that scenario would be an estate in sufferance. Because now the landlord, who could be making progress toward providing that space to a tenant who's gonna pay more money, who's more creditworthy, who's better suited to the long-term health and value of the building, can't get them in because the old tenant hasn't left. Under an estate in sufferance in Illinois, it's statutory that the tenant is automatically obligated to pay double rent when they hold over. That can be waived by provision of the lease, of course. Savvy tenants will try and negotiate that out. Landlords may want to think twice about giving them that right to do that. But automatically, and that's one way to get a small business out, is to send them a notice. You notice you overstayed, you had no notice, you're in default of the lease because you gave us no notice, and by the way, just to make sure you understand, effective immediately, you are now paying us twice the contract rent. They may not be aware of that. So that's an estate in sufferance, where the landlord is literally suffering under the burden of the tenant being there. An estate at will is you don't have that other tenant, you don't have that insurance company or bank branch or whomever you're gonna put into that space, and instead, when the tenant stays, you go, oh, cool, I guess they weren't ready to move into their new restaurant down the street or whatever, because now you're okay with it because you're just gonna get another month's rent. You don't have a new agreement. You haven't entered into anything formal, but you're okay with it, so the tenant can stay under an estate at will, at the will and pleasure of the landlord, basically. So that's it. You either have, when you have a holdover kind of arrangement, an estate at will or an estate at sufferance. And under an estate at sufferance, the double rent sometimes will ease the burden of the landlord. Though I will give you a quick story of where that sometimes doesn't play out so well. So how many of you are familiar with the driver's license facility in Aurora? So most of you, okay. So the state of Illinois is a little bit funky to deal with at times because they are, well, the king, and sometimes the king is just annoying and plays by his or her own rules. And so on the first renewal for that location, I believe, this goes back a few years, maybe 15 years back in time. No, 20, actually, I think it would be. No, 15, sorry. Anyway, when the first renewal was coming up for that, the state did not bother to sign a new lease. They were too busy, short-handed, whatever, and so they just stayed. They held over. And so the savvy landlords of that building did what? Charged them double rent. I think for 3 years, the state paid double rent for that space. After 3 years, the Department of Central Management Services, which handles all leasing stuff for the state of Illinois, struck a new deal with the landlord. And of course, what did they insist that the landlord do as part of that deal? Pay them back all of the double rent. If I had 3 years of the state's money and had a chance to get the hell rid of them, I would have taken it. But maybe I wouldn't have known that, whenever that was the case. I literally happened to be sitting in the one of the main investors' office at the moment when he got the phone call that the deal was done, but that was part of the deal. Kind of had to laugh and not laugh all at the same time because we have the state as tenants across the street as well. Again, these are contracts, so everything about them is negotiable. Steve?
In the case of double rent, is it prorated per day or is it for the entire 30-day period?
No, it's for the entire 30-day period. It's like once you hold over a day, theoretically, you owe for that next period, that next month. Now, if you really, if somebody literally just couldn't get their restaurant equipment out fast enough and they were still there on the 1st of June and just moving out and by noon or 2 in the afternoon they were gone, and you tried to go to court to collect to get a judgment to force them to pay a month, I don't know that a court would side with you, in that kind of a case, that kind of scenario. Because theoretically you're only damaged by 1 day, and what's that really, what was that really worth? But in theory, anyway, if you go to a period, it's typically you've got to be looked at on a monthly basis. If they were paying rent on a monthly basis and they hold over even for a day or so, it should be for a full month's worth of rent, I would think. Unless, of course, you have some provision to the contrary. The state, by the way, now no longer pays double rent. They insist on whatever the ending rent was to be their holdover rent, which is annoying because then they will just stay and not negotiate with you. The last time I signed up the state, they were a holdover for 3 years in one space and almost 4 in the other. And they finally came to the negotiating table around the same time I started threatening to evict them and charge them double rent. Then they found, oh, we got to do something. But during that 3 or 4 year period of time, the rent remained the same as it had been. So we got no increases for inflation or anything else for that 3 or 4 year period. Just, pardon me, damned annoying. But you know, that's how they played that. All right, so just like we talked about in chapter 11, these same things I talked about earlier tonight, these same things that are required for a lease to be valid. Must have capacity to contract, which, again, majority age 18. Not at all uncommon if a 17-year-old's going to go rent an apartment out in DeKalb to go to college early or something that one of their parents or some other adult would co-sign, take on that obligation, fulfill the capacity of the contract, take away the right to void or avoid the contract. Has to have a legal purpose of some kind, and this actually happens, I think, probably more frequently with leases than it does with other types of contracts where something isn't for a legal purpose, which I'll explain in a little bit. Offer and acceptance are really meeting of the minds, right? I mean, the idea that that you know what you're paying for rent and you know what you're getting for space. Some kind of consideration, and the consideration is actually the rent and the conveyance of the space. So security deposits are not consideration, just like earnest money was not required. So by law in Illinois, by the License Act itself, a security deposit is defined as earnest money, and they really fulfill the same purpose. Different kinds of conveyance, but they fulfill the same kind of purpose. Neither one is consideration, and neither one is a requirement under the law. Parties want them for other reasons. So again, the consideration here is the rent and the conveyance of the space, and whatever rights come along with that. And of course, again, mutual assent, the idea that there's an actual agreement that people really know what they have. So, this is an important sort of thing to look at. All right, so let's talk a little bit about how a lease might not have legal objectives. So let me ask you, what would be a case where you have a lease and the parties think they have something legal and it turns out they don't? How could that happen? Think more in my world, not residential, but commercial type space. Yeah, it's zoning. Ozzy moves in, opens his restaurant, and 6 months later, the city says, no restaurants in that location, and and the law is going to take effect even against current tenants in 4 years. Well, in 4 years, as soon as that law would take effect, if that would retroactive kind of thing, which you don't normally have in a zoning case, but it could, in theory, that restaurant would no longer be a legal use. I've had this happen to me twice over in my leasing type career. In one case, we had a tenant that was operating a massage parlor that actually turned out to be, well, a massage parlor. So since they weren't there for a legal purpose, apparently, once they were, raided by the village of Richton Park, we really couldn't go after them for anything because we didn't have a lease for a legal purpose, apparently. And then another was a zoning case. This is Aurora, and this was a situation where we agreed with a nonprofit to put a drop box, a charity drop box, where you put clothing and things, whatever, in front of the property. And that's not allowed in many places in Aurora because the city of Aurora thinks it kind of junks up the view. So we were told that was a zoning violation for our area. I had a written signed lease with the nonprofit, which all of a sudden I knew was worthless, right? Because I couldn't force them to pay rent. They couldn't force me to let them stay. It just was an invalid, agreement. And so we just kind of let them get rid of the box at their pleasure. I think they stayed and paid us for about 5 or 6 months while I wrote stupid letters back and forth to the city because I liked the $100 a month income I was getting for doing nothing. But there's no legal lease, right? It's not for a legal objective. So that's the case that happens, the kind of thing that can happen in leases in particular. If you have a problem with zoning, you can't do what you're doing, then it's automatically not for a legal purpose, even though nobody was trying to evade the law or commit a crime or whatever.
Well, what about in the case, let's take vapor stores, for example, those cigarette things?
Yeah,
Okay, so that's kind of a free-for-all right now. What happens when all of a sudden there's some restrictions on that and their business is cut down 75% because?
well, let's take something that's even more common, you know, bigger challenge today for some landlords, medical marijuana dispensary. So you have a medical marijuana dispensary in your building, and then Illinois decides to go back and change that law and say, no, we don't want to do this anymore. As soon as the new law is passed, or as soon as the law, new law takes effect, or the old one expires or whatever, you no longer have a valid lease regardless of when it was going to expire. You can negotiate something different, sure, now you can have a, now you can have a newspaper stand there instead or whatever. I mean, you could change that, but otherwise, without some kind of mutual agreement, the lease would terminate when the law makes it impossible. So if you have, an e-smokes kind of shop location, and the city then comes back and goes, no, we're now going to treat that the same way we treat other tobacco shops, and you don't have the right permit, or you don't have whatever for that, you would immediately, instantly have no valid lease for that location, even if you had what you thought was a valid lease. It's no different than having, say, the Iranian National Oil Company leasing ground from you for for petrol station, for a gas station, and then a sanction comes out that you can't do business with any Iranian companies. That lease would be instantly void, and you would not be allowed to do business with them, nor would they be allowed to stay. So I think it's just that simple. There are times when both the tenant and the landlord would like to fight the same law, would like to go argue against it. And it doesn't have to even be, an all or nothing thing. So I guess getting back a little bit, what if it's just sort of toned down? So what if you've got a vape shop, and it's, 1,000 feet from a school, and the old rule was 500, and now the new rule is you can't be within a mile of a school. Well, then, same kind of thing. You might instantly, if there's no sort of grandfathering of that, you might instantly have a lease that's, not valid. Same thing would have been true instantly with prohibition. Anybody that had a liquor store, bar, whatever, right, if that's what you've got, immediately, you'd either have to convert use, or the lease would no longer be valid. And which means neither party can get enforcement in a court. I can't force you to stay. You can't force me to make you stay. That's not the norm, but it does happen from time to time. All right. See if I can remember what I wanted to talk about here. All right, so I guess, in terms of just negotiating leases, whether it's from a standpoint of being a broker or from the standpoint of being a party to them, residential is much simpler. We tend to work off of standard contract forms. Again, you get an Office Depot, Office Max, Staples, maybe they even have them at Walmart, whatever, or online from a site like nolo.com or LegalZoom, or you could probably find them on some attorney's website where you can copy and paste it or whatever. There's just all kinds of standard form agreements from which parties could work if they so chose under residential deals. It's possible that a realtor association or some kind of professional real estate organization might have standard lease forms available for people to look at and modify, in Word format or whatever. And again, it's pretty, straightforward. You don't need an attorney as an individual to walk into an apartment complex and negotiate a lease, right? It's pretty much you're going to sign their lease, or maybe make some minor modification or something, or you're not. It's pretty straightforward kind of thing. But when you get outside of that world, no two deals are the same. It's not cookie cutter anymore. It's fairly complex, and so attorneys have to get involved. So under a commercial and industrial leasing kind of scenario, these are typically attorney drafted. Again, usually they're the landlord's draft lease, and oftentimes that standard lease will be conveyed to the tenant's attorney. Not if it's your first business. If you're going to open a resale shop and you want to sell somebody's used clothing for in a 1,200 square foot space and see if you can make it doing that or whatever, and it's fairly small, you're probably not hiring an attorney, and you're probably not going to go through that. But businesses of any size or substance or any kind of public agency or entity are going to have their own attorney, and that attorney is going to be hired to review the contract. It is not at all uncommon for me to negotiate a lease with not the other party, but with the other party's attorney, and then have to decide on my side as a property manager or owner, do I want to bring in legal counsel and pay them to look over, what we're doing to modify what is typically our standard lease form that we're changing. And there are standard lease forms to work from. There are organizations like BOMA, the Building Owners and Managers Association, that has a standard lease form. There's the Building Owners and Managers Institute, which has standard lease forms. But hardly anybody uses those standards. They usually pay for membership, then they import those standards, and then they modify them to meet the criteria of their building and work from there. So we start off oftentimes with something called a letter of intent. Again, I don't know that you get tested on this. I don't think there's anything about this in the text, but I want you to understand that there's an entire another step here. And this letter of intent process could also end up being involved in commercial or industrial sales. So a letter of intent is a way to agree without agreeing at all, but make everybody sort of stop and pretend like they're agreeing so that the space doesn't maybe disappear on you. It's a delicate legal dance, basically, because what is a letter of intent? Is it binding on the parties? Is it non-binding? Because if it's binding, then all a letter of intent is maybe a lease under a different name. But basically what the parties will do is one will send a letter to the other, usually it's the landlord to the tenant, saying, we're willing to lease to you on the following basis. We want X dollars per square foot for this number of square feet, minimum number of years, and in return for that, we'll do the following amount of build out or provide you with an allowance for you to do it. And here are our building rules. Here's what you're going to get for the space, that sort of thing. Now, if you write it in such a way that it sounds like an offer and the other party accepts it, then that letter of intent was binding. And now, as the landlord, you're stuck doing just that. In fact, a court might even construe that letter of intent accepted by the tenant or the prospective tenant became a lease in and of itself. A poorly defined lease, but a lease. Where your intent probably is to say to the tenant, well, this is what we're willing to do, but don't construe this to be an offer. This is, our intent of what we'd like to do. And the tenant is probably looking for something non-binding as well, unless it turns out later that they really wish it was to be favorable. So, again, a delicate legal dance to figure out whether this letter of intent is binding or non-binding. In a lease drafting course in law school or in a graduate law program, they spend a lot of time on this kind of thing. I suppose I was kind of supposed to be paying attention during this period. But it's complicated, and it's not the kind of thing I retain because I have to really use it. But I have to know when I manage an attorney to look over something for me, what have we got here? Is my letter of intent binding or non-binding? Again, the same kind of letter of intent thing could work in sales. So since you don't have standard commercial sales contracts typically, the parties would typically draft first a non-binding, hopefully, letter of intent, and then one of the attorneys would also write up a sales contract that when the parties agree it's mutually acceptable, then they would sign it. And the period of time can take weeks, maybe even months while negotiations go on for legal and other kinds of issues, and all you're doing is kind of working with this non-binding letter of intent, which is each party's good faith way of saying, I'm in, as long as we don't have any major hiccups between now and the time you actually sign up. Okay? So this is an important fill-in-the-gap kind of process that otherwise you might not know existed, but you should be aware is there. Construction, as it relates to leases in a commercial or industrial kind of scenario, is also significant, or can be. Right? If you're going to rent an apartment, you move in, and either the carpet's in decent shape, and it's been recently painted, or it hasn't. And maybe there's repairs or maintenance. Hey, the bathroom door doesn't latch properly, or hey, did you just repaint this because I can still see a bunch of places where the holes in the wall were patched, or whatever. It's pretty straightforward stuff. But when Ozzy wants to open, a restaurant in my building, the question is not just, who's paying what for, what's going to pay for rent, but it's also who's going to build the thing out, who's putting in the counters, and who's providing the equipment, and who's putting in the major exhaust fan up, through the roof and that kind of thing. Who's going to increase the electrical service to handle the cooler and the freezer? All that stuff has to be sorted out. So build out, the idea of tenant build out is the idea that somebody, either the tenant or the landlord, is gonna pay a significant amount of money to prepare that space and turn it into what we need it to be. And that all has to be well-defined ahead of time and is part of the lease negotiations. Indeed, in some complex lease scenarios, the construction-related documents will be thicker than the lease itself. And depending upon what you're looking at as a landlord, this can get pretty hairy. So for example, I don't really like the idea of just any contractor working in my building. If that contractor comes in there and doesn't do something right, who knows what kind of damage they could cause or problems they could create. And what happens then if there's a dispute between them and the tenant? Who's the contractor going to place a lien against? They're going to possibly place a lien against my building for something I had nothing to do with. Tenants, on the other hand, don't want me to do the build out because they don't know whether I'm overcharging them or not. And invariably, a number of tenants will have their brother-in-law, or maybe it's a dentist and they're working with dental suppliers who will have contractors they work with, and the dental supplier wants to be involved because they're trying to sell them the equipment, and so they work with the contractors who do a lot of medical office and dental office build outs. And so the dentists come to you and say, we want to rent, but we want to use our own contractor, which they don't even know who they are, but they know to get favorable treatment from their suppliers, who will sometimes draft what the dentist office should look like, right down to where all the sinks and chairs and everything are going to be, and the model numbers and everything for them for free as part of their service, again, to get the equipment sales and all the follow-up material sales and supplies and things. They'll come in and say, well, we want to do our own build out, even though they don't have a contractor, they just have somebody else who can get them one. So you got to sort out how you want to deal with all that stuff. It's not easy, it's complex. All of which is to say that it's just a different world here. And if you're into construction or you're into this kind of thing, there's value to that kind of knowledge or that kind of understanding, because you've got to be able to sort of make your way around that kind of thing. It's not at all uncommon to find somebody, for example, who has worked in industry who will end up doing industrial leasing or brokerage because they've been working in warehousing and distribution facilities and they know the buildings. I went from construction to real estate, residential first, but then to commercial, in part because if this is the office building, this classroom building we're sitting in, if this is the office building that I have to lease, I'm dead certain, without even looking at a set of prints, that none of these interior partitions are load-bearing at all, just based on my experience. So if this whole floor were just recently vacated by the college, for example, and were my responsibility as a broker to re-lease this, I would instantly know that I could recarve this space up in almost any shape that would make sense. I just have to maintain the exits, whatever else would meet code, because I know enough about construction to know this is a steel frame building and these partitions are not load bearing. And you can even tell in some cases just by looking at them, they don't always necessarily even go up to the deck above, they stop at the ceiling in some cases. So if you're, again, come from that background, that kind of knowledge, it makes sense to be involved and do that. The tenant improvement allowance sometimes is just a cash number that the landlord will say to the tenant, here's our standard office building, we'll give you a white envelope or a vanilla box, plain space, but we'll also contribute $10 a square foot, $30 a square foot, whatever, to your build out. After that, anything above that, you pay for it yourself. Buildings have standards, an outlet every 10 feet, 200 amp electrical service, a single phase electric, for example, whatever, this is what we'll give you, a half bathroom in a 2,500 square foot space, whatever. These are the standards we're going to give you, and anything above that is either going to be covered by the TI allowance or you're paying for as a tenant. And then there are a couple of ways to deal with that. The tenant can pay for that over time in higher rent, and the landlord underwrites the cost, and the tenant just pays more money over time to cover that. Or the landlord can say, we don't trust you, go get your own loan. You get a loan from the bank for leasehold improvements, which a lot of medical people can do, some small businesses are able to do, get their own financing, and then you take care of paying for the build out up front, and then you can pay that loan back with interest over time. Remember, one of the things a landlord does is extend credit, and you can extend credit if you have the cash or have your own borrowing capacity to tenants directly in the space if you want to take that risk, if you think they're creditworthy. Questions about any of that kind of thing? Again, what I really want you to understand is commercial and industrial leasing is complex. Not impossible, but it is far more complicated. All right, I'm just trying to think here when the best time to take a break. I guess we'll go on one more section thing here. All right, the book talks about possession, and we've talked a little bit about the bundle of rights already, and particularly about possession and enjoyment, these kinds of things that kind of go along with it. Let me just see real quick. One other thing I want to mention, I want to see if I have it elsewhere here. Yeah, I do. Okay. All right, so we talked about quiet enjoyment and the fact that it's the tenant's space and the tenant's right. Some of the notice requirements that are important for landlords, what about maintenance? Right, I mean, and it's important even for a residential tenant to know, if the maintenance guy comes and knocks on my apartment door Friday night at 11 o'clock, so you're a single 20-year-old woman, let's make it extremely attractive to make this even further complex, who lives a life of constantly being harassed by men or whatever, and now at 11 o'clock on a Friday night, the maintenance guy is knocking on the door. Hey, I got to get in and take a look at your pipes. I think you sprung a leak. Does she have to let him in? Not let him in? I mean, kind of depends upon how the lease reads. Depends upon what the circumstances are. So if this is just some routine maintenance thing, hey, I just kind of coming around checking to see what's going on with your plumbing or whatever, and I think you just schedule a reasonable time. But if it's an emergency because the tenant down below is getting water pouring in from their ceiling, and the maintenance guy needs to get in and see is something happening with the water pipe inside the wall or below, are you a leak in your bathroom or in your kitchen or whatever, then you probably have, doesn't matter what the lease says, you probably have to let them in. In cases of damage, potential damage to life or property, then really all bets are off. Landlords have the right to get in to stop a fire, stop a leak, whatever. But routine maintenance, there should be something in the contract. It should state 24 hours notice, normal working hours, whatever. And if an apartment landlord, for example, wants to come in and do routine inspections, you want to reserve that right in the lease. I've seen investor days at apartments. Well, this is once a year, we're going to let the investors come through and see what their money is getting them. Well, then they got to give you some kind of notice. You'll want to know what that is. So most places today will give you, a postcard or, whatever a week ahead of time, so you'll know. And of course, you don't have to be home. They're happy to come in. They're going to be in and out in 5 minutes. They just, want to show their investors what their assets are looking like in general. And they may not even inspect every unit. Again, all these things need to be dealt with, including what kind of notice has to be done. As I mentioned earlier tonight, showings, there's a couple of things. If you're going to sell a property, it's a pain to sell residential property if you have no right to get in it. Can't get your people in it. This is especially problematic for unsophisticated owners of like a 4-flat or a duplex, where you didn't craft any notice requirements or any ability to show that space, and now you're a broker, and you're calling the tenants saying, hey, I got to get in there, tomorrow morning at 10 o'clock to show the space, and the tenant's like, what? I'm not going to be home. My place is a wreck. Whatever. Comes down to what the lease says. So if, as a broker, you take a listing to sell a leased property, one of the first things you're going to ask for are copies of the leases. First of all, you need to give copies of those leases to seriously prospective buyers after they sign a confidentiality agreement or whatever other restrictions you place on their ability to use that information. But also, you need to know what kind of notice you have to give, and that would be defined in that lease agreement. And then just, for leasing. So if I'm renting apartments, when can I show them? I don't want to wait until they're vacated. That's too late. I need to get people in ahead of time, right? I want to minimize the time that the units are vacant in the property that I'm managing or investing in. So if it's going to take me a week or 2 weeks to shampoo and to paint and to deodorize and to check things and whatever, I don't want to, I don't want to be showing that property only during that time period. I would rather know that, okay, in the last 30 days, if I can make that property available to show to somebody, and then I can do those fix-up kinds of things as those people are maybe moving in, or they can move in the day when I'm finished. The tighter I can schedule it, the less vacancy I have, the more rent I'm generating. But again, you need to get an early start on that, so you need to know what that is. So again, these are notice items that I'm just kind of putting down here and restating, but also memorializing them for you so you understand that these things matter. whether you're the investor or whether you're the broker who's gonna have to deal with the property, you really can't deal with it unless you've got options. And again, without them deciding to be specified in the lease who has all the rights, the tenant. That's why it really matters. Here's where the book talks about use, and it doesn't really mention what I think is important. So let's start with the basics. So in the lease, it'll typically restrict how the tenant can use the property. This is an apartment, it's for residential, and you can only have a certain number of people living in it, whatever. You're not to run a business out of your apartment, for example. That theoretically could be in there. That's the basic idea, to restrict the tenant's use to something. And you can restrict it, any way you want. That's legal. So if I'm renting to a general medical practice, I might want to say to them, yeah, you can do whatever medical procedures you want here, but no abortions. I don't want any abortions in my building. I may not even care personally, but I don't want the notoriety. Or I may have partners, for example. So I could have a convenience store, but I might have partners who say, but we're no alcohol. We don't want to invest our money in anything that's where you've got a liquor store. So you can have a convenience store, but in the city might give you a liquor license, but we don't want it. So you can have those kinds of restrictions. You want to have a medical office, that's fine, but we're going to or a dental office, but we're going to restrict it to general family dentistry because we already have an oral surgeon in another space in the building, and we don't want the competition. So you can do that. And if it's a legal restriction and the parties agree, no problem. But what I really want to point out here, and that's not at all in the book, but it's equally important, is that tenants, because this is a contract and it's bilateral, so it cuts both ways, tenants also have the ability to restrict the building owner's ability to use the property or to lease the property in a way that the owner might otherwise wish to do. So let's think about retail. This is the easiest place to think of this. So just think about any retail center and imagine any tenant in that center that you want, pick any tenant you want, and think about how or why would that tenant want to somehow limit the landlord's rights in leasing spaces in that particular center. What's the tenant trying to do? What are they concerned about?
Competition.
Yeah, exactly, competition. A non-compete clause. So if you want me to open my grocery store, my ethnic grocery store in your center, where we're going to sell food that's halal or kosher or whatever, here's what the stuff we're going to sell, and we don't want anybody else in the center who's selling that. Or I'm Walmart. You want me to anchor your center? That's fine, but we're going to be the only grocery store, or we're going to be the only one who sells this or that or the other thing. Or I'm 7-Eleven, and you want me to anchor your little 10,000 square foot center, and I'll take a quarter of it, that's fine. But we're the only ones who sell lottery tickets. We're the only ones who sell alcohol. We're the only ones who sell prepared and packaged foods. We're the only ones who sell tobacco. Whatever their big draws are, they may want to have these exclusives in there, which means you now have the rest of that building, which is not quite as leasable as it otherwise might be, because you've got these restrictions. Savvy tenants have to look and see, what kind of tenant mix do we want? Which sorts of tenants make our business better, and which kind of tenants would make our business worse? Many tenants will only lease so long as the anchor is still in place. So also many leases have what are for retail also have go dark clauses. Once you lose a certain number of tenants, we have the right to walk. Or if you lose Walmart in this Walmart anchored center, their lease expires in 20 years and they go, our lease, no matter where it's at, we have the right to pack and go. Because what generates all the traffic at the center? It's the big anchors that people come to, the Targets, the Walmarts, whatever. Right, if you take a look at the mall in North Aurora that faces I-88, but that sort of backs up to the auto mall and to whatever that road is that comes across from Oberweis to Orchard. That mall, right, within the first year or two that it opened, who packed up and left? OfficeMax. They're a big national firm, publicly traded company, and granted they've had some challenges. They were gone almost by the time they opened. Clearly, people were not going to that center just to go to OfficeMax. And how many other places have closed in there since? I think there's several. So who are the big traffic generators? Target, and hopefully JCPenney, but that's also a smaller JCPenney store than you get like at Fox Valley. Everybody else is counting on those two to draw traffic. So I'm willing to bet in that center that those national chain smaller stores have clauses that say if Target leaves, we're gone. It might even have something that relates to Best Buy, which is across the parking lot or whatever, because they need that traffic to make the numbers make sense for them. So again, tenants can restrict what landlords can do, both by saying who you cannot lease to, or also indicating who you must keep leasing to, and if you fail to do that, then they have the right to leave, or to have lesser rent, or something. So I just want you to be aware that that's out there, because again, the text presents this really kind of simpleton view of, don't forget, as a landlord, you can restrict the tenant's use of the property. Well, don't forget, it can go the other way. And those kinds of restrictions can be devastating. Again, it's the kind of thing that I've seen, where you got a space and you know you can lease it, but you can't lease it because you got a lease somewhere else in that building that prohibits you from renting it in such a way. As a landlord and as a property manager, I hate exclusives. I hate the idea that I can't rent to somebody else. So when tenants want that, I often push back. We had a brokerage firm, for example, a Century 21 office in a building in Hyde Park, down near where the president lives, that had been in the building for, I don't know, 30 years. And it sold to another broker, who owned this Century 21 franchise. And when the lease came up to renew, she said, I want an exclusive. I want to be the only real estate broker in the building. And my initial response was, impossible. We have an office in the building. We're real estate brokers. Then she said, well, I other than you. Still impossible. We have an apartment leasing and management firm in the building who's already there, who's been there for a number of years. They're also brokers. It took a number of trips back and forth legally to carve out a clause, and instead of giving her a complete exclusive, we gave her the right, we told her the rent would be dramatically reduced. I would rather have that and have the right to lease to somebody else, knowing that I might lose these people, and in the meantime, the rent's going to go way down, but it's not an automatic. I'd rather have something than have no right to rent at all. Just I'm trying to retain some control. So again, a lot of negotiations in these kinds of scenarios. I think I mentioned lease term already. That just again, length. Residential is much shorter. Commercial, industrial tend to be much longer. Questions about any of this stuff at all? All right, let's take a break. Let's come back. Why don't we make it somewhere between 8 o'clock and 5 after, when everybody's here and ready to go.